Thank you, Mr. Chairman. I appreciate that. I want to thank the witnesses for your testimony. Ms. Moy, on the question of federal preemption, when we talk about complete federal preemption, we're talking about a federal standard, and at least as far as this legislation goes, we're talking about federal enforcement as well, that's being taken away from the Attorneys General of the states. And even further, it looks like the notification for breach will be taken away from the FEC and given to the FTC. So we're consolidating that as well. And as well, it might involve, if I'm not sure if I'm getting this correct, if we have a federal standard and a retailer or a business complies with that federal standard, does that imply some type of immunity for that individual retailer if they're complying with what the feds require? Is that also holding them harmless from any liability?
I'm sorry, you mean in an environment where this creates a floor and not a ceiling, and states continue to have? This
would be a complete obliteration. This would be just total preemption. So you'll have one standard. You could call it it would be a ceiling. It would be a ceiling. So is that implying some type of immunity or protection from liability for the complying company?
Yeah, I mean, a company would then only be liable as it would be held liable under the federal law, and any additional obligations of the state law that had previously existed would no longer be actively enforced against them.
Right. Under this legislation, that would be problematic because of, as your testimony indicated, it only recognizes financial harm. Right. There's a trigger. Well, actually, there's a financial harm trigger, and I think there's also a trigger for a very narrow set of personal information.
Actually, I'm not sure if there is. I think I thought that I was under the impression that the financial harm trigger applies to everything, but perhaps you're right. I'll take a look at that. And
if I may, Congressman, the provisions of the bill of 2205 also provide for triggers related to identity theft as well as financial harm.
Right, yes, but although many states, as I noted in my written testimony, have either no harm trigger at all, recognizing that consumers want to be notified of the breach of certain classes of information and want to be able to safeguard that information regardless of whether or not it could be used for identity theft or financial harm. And a clear majority of states have either no trigger or a trigger that's broader than just financial in nature.
One of the problems I have is that this introduces a federal standard, and it takes out the states. Massachusetts happens to have a very robust consumer protection, privacy framework that I think will be harmed. And we also we've been blessed with attorneys general that have been very active in defending consumers. And some of those cases, as you pointed out, I think the average case of breach in Massachusetts, we had 2,400 last year, but the average size was about 74 consumers. So that's not the type of thing that the FTC is going to go after, in my opinion.
That's right, and that's why we think it's so critically important. If we want to ensure that all consumers are protected by a federal standard, it's really important that we have as many people keeping an eye on what's happening with breaches and working with companies to help develop their security standards and working with consumers to respond after their information has been breached and to watch out for potential harm that could be coming down the pike. It's really important to have the involvement of the state AGs and all of that.
And if we did introduce, and I'm in favor of introducing a very high floor across the board that I think would subsume maybe close to 40 states. But I would like to have that flexibility for states that, well, number one, they're more flexible. Congress is not known for its speed at all. And so having the states out there with the ability to provide additional protections, especially in the face of the sophistication of some of these hackers, is very, very important in my mind. There is some incongruity in this bill. It talks about a federal standard, but then it says every covered entity will be responsible for adopting a system of security protection that is commensurate with their size, their complexity. The gentleman from North Carolina just brought this up in a different context. But how do we deal with that, where a pizza shop, a coffee shop, a bank, well, banks are a different class, but each and every company is going to be able to right-size the level of protection, but in reality, that stream of information that is breached may not be compartmentalized.
I'm sorry, what do you mean by the information may not be compartmentalized? I'm sorry.
Well, if they hack into your as you said, your email and your password, that opens up a whole other door of information that they can access that might not be readily evident, based on where they entered the stream of information.
Right, sorry. May I just respond to
A very brief answer.
Sure. Yeah, I would just say there are certainly login credentials that because people recycle passwords can be used across accounts, and that's an important reason for.
All right, thank you.
Time of the gentleman has expired. The chair now